In this final video, we move on from issues which might undermine the validity to vitiating factors. You'll remember in the last video, I outlined how validity is kind of the bouncer not letting you into the club because what you were doing wasn't correct, it wasn't lawful, or one of the people didn't know what they were doing, or it wasn't in the right form. Like you can't get into the club because you don't have your ID. So if you don't have your ID, you can't get in. If it's not in the right formality, you can't get in. If people don't have capacity, you can't have a contract. If it's unlawful objects, you can't have a contract. The contract will be unenforceable. Now we move on to vitiating factors. So why don't we have a look at our espresso drama here to think about what we've been learning so far. So with our espresso machine, remember we had to work out what is an offer versus an invitation to treat. We had to look at whether things are accepted, right? Whether we have an offer and acceptance to get us agreement. We looked at the fact that these are two businesses, so we probably have intent. We had an issue about whether wanting it for free is sufficient consideration. And I'll just notice that he said he's going to put the logo on the counter. So he is doing something, so it probably is sufficient consideration. So we've got agreement. Well, there's a question about whether we have agreement, but we've got questions of agreement, we've got questions of intent, we've got questions of consideration here to think about. We also, in terms of validity, looked at the capacity issue because our cafe owner is 17 years old. The final area in vitiating factors from our problem is this statement here. So just to remind us, Percolicious has sold the last Pro X to someone else, but Wednesday Jordan really wants to get one. And he talks with them and says, okay, but given the stuff up and the fact that I've been trying to order it and not get it, I want it for free and I'll put your logo on the counter for 6 months. If you don't, I'll blast my followers telling them exactly how you can't be trusted. This is a kind of pressure. Right? In fact, some would say it's a possible threat. And this brings to light the issue of vitiating factors or genuine consent. When someone uses this kind of approach as a negotiating technique, can we say that Percolicious truly consented or truly agreed to sell the machine? Or were they doing it because of this threat and there wasn't true consent? That's the kind of issue that vitiating factors try and deal with. Now, vitiating factors cover a range of things, and indeed misrepresentation, mistake I could possibly put in there. There's some things that we're not really going to deal with because other areas of law take care of them most of the time. Misrepresentation, for instance, well, I will probably touch on them as we go through the rest of the slides, but the two that I want to concentrate on for this subject are undue influence and unconscionability. Duress, I probably would hope that you're not going to threaten people, so that's duress, outright threatening people, but trying to influence a negotiation and use pressure, I think that's something where there's a fine line in business between where it's a legitimate negotiation technique and where you're actually taking away someone's genuine consent. So that's why these two areas are the ones we concentrate on for vitiating factors. As we've been saying, a key issue with vitiating factors is that there's no true meeting of minds because one of the parties was pressured into it. The result of this is that the weaker or manipulated party has the choice to void the contract or not. So the person who's done the wrong thing, they're in a contract. They can't use this to get out of it. It's the weaker party or the party who is manipulated who can make the contract unenforceable. That means the other party can't make them go through with their end of the bargain. So they can't make them pay for an outrageous purchase, or they'd have to give the money back if they had paid, etc. So that's what we're dealing with. As I mentioned, we're not going to deal with duress because hopefully you understand the idea of threatening someone or their property or their economic well-being. That's a little more detailed again. So just be aware if you threaten someone, like in our scenario, their economic well-being, it may be duress. Misrepresentation, false statements of fact. Again, it's a pretty technical area. A lot of it now is covered by Australian consumer law. So I would suggest that's a better area for dealing with this kind of issue, although we do deal with negligent misstatement as part of negligence in the course a bit later. So we'll come back and talk more about misrepresentation there. So that leaves us with two key things that we might want to look at: undue influence and unconscionability. So undue influence occurs where parties to a contract have, and this is super important, a pre-existing relationship where one party has some influence or dominance over another. So an example of this would be if I contract with you. Why? Because we have a pre-existing relationship, lecturer-student, and to some degree I have influence over you because I set your grade, right? So I could unduly influence. If I said, hey, wash my car for $2, and you agree, I'm not sure whether you're agreeing because you want to wash my car for $2 or because you're worried that I might mark you down. Right? That's what undue influence is. Pre-existing relationship with power. Now, if the stronger party uses that influence, and to an outside person, it looks like the weaker party is not really exercising independent judgment, the contract is voidable by the weaker party. Now, because it's common law, there's been some precedents. So undue influence is presumed in doctor-patient, lawyer-client, trustee-beneficiary, parent-guardian, religious leader and follower. Not too many business things in there, right, that we can see here. Although, there are business relationships. I think if you put accountant in there, you'd have the same thing. Any professional relationship, they probably have influence over your decision-making. So how do we work out whether undue influence is in play? There's two ways. One, you'll remember under the doctrine of precedent, if something's been decided a certain way, courts must follow it. So if there is a relationship that a court has decided there may be undue influence, other courts have to follow it. These are presumed relationships. However, if you're not in that list of relationships that courts have considered, then that influence is not assumed. So in the case of a relationship that's been before a court, it's assumed you had influence. If it's not one of those, it's not assumed you had influence. So that's the first thing we've got to do. Now, if you're in one of these presumed relationships, the stronger party has to show, so the stronger party, the person with the power, has to show that they did not exert their influence. If they can't do this, the contract is voidable by the weaker party. The weaker party can get out of the contract. So in this situation, you and me, where I get you to wash my car for $2, I would have to show that you used your own free will for this $2 deal. Hard to do given how little money was involved. What I could do is say maybe if I ran a tender, an arm's length process, and you won the tender, that might show it. That would be an example of how to do it. But in the example I gave, if lecturer-student was a presumed relationship, no. Now, notice if I go back to the list, and again, this is not complete, this is for our subject. So if it's not on this list, assume it's part of the second criteria. So I don't actually see lecturer-student or teacher-student on the list. It would be, by the way, but let's pretend it's not. If our relationship was here on this side where it was not assumed, you would have to show that I had a controlling influence over the decision making. You would have to show that I had influence. Now, the way this works most times is that people show a pattern of one person making decisions for another. If the weaker party, so in our example up here of you washing my car, that would be you. If you can show that I did have a controlling influence, the onus then goes to me to show me I didn't use it. So what you've got is two steps, right? In both cases, the stronger party has to show that they didn't use any influence, right? This happens in both cases. But there's an in-between step for this second case where the relationship isn't a recognised one. If the relationship isn't recognised one, the weaker has to show the stronger had influence. Okay, so that's the difference. If there's been a case and there's a presumed relationship, the stronger party has to show they didn't use it. If it's not one of the presumed, then the weaker party has to show the stronger party actually had influence. Once they do that, we go back to the same rule. The stronger party has to show that they didn't use that influence. So again, the key to undue influence is a pre-existing relationship where one person has some dominance or influence over the decision-making of the other. That's the hallmark of that particular vitiating factor. The next vitiating factor can sometimes look like it, and sometimes you get both of these at the same time. But the difference is, with unconscionability, there's no pre-existing relationship. So let's get into the rule around So what is unconscionability actually about? Well, it's really about dodgy conduct. You're being dodgy when you're doing the negotiation. You're being unconscionable. It's beyond dodgy. It's unconscionable what you did. And a contract can be set aside if you undertake unconscionable conduct. So what's the common law test? Noticed, ands, so we need all three. One of the parties to the contract has a special weakness or disadvantage. So a party has to have a weakness. This is the defining factor in unconscionability, particularly at common law. One of the parties has a special weakness or disadvantage. The other party knows about it or should know about it. Why do you reckon they say should know about it? Because people might lie or people might misremember that they knew about it. It's saying, would a reasonable person know that that person had a special weakness or disadvantage? So if one of the parties has a special weakness or disadvantage and the other party knows about it or should have known about it, and they take unfair advantage of that special weakness or disadvantage, then the weaker party could have the contract set aside for unconscionable conduct. The classic case of this is the Amadeo case, Commercial Bank of Australia, which I think became the Commonwealth Bank, and Amadeo, which is where you had an old Italian couple who didn't speak a lot of English, and they were asked to guarantee a loan for the business of their son. Now, their son's business was not going too well, and the bank knew this. And the bank didn't make it clear to the elderly couple that there was a high likelihood they were going to have to pay up for the failure of their son's business because it wasn't going well by taking out this mortgage. In this case, the court held the bank's behaviour was unconscionable. The Amadeos had a special weakness or disadvantage. They were elderly and didn't understand business. They didn't even understand English terribly well. So they had no real idea about how the business was going. The bank knew or should have known that. I mean, just talking with them, you probably would have realised that they didn't understand what they were signing and the precarious nature of their son's business. And the court held that in this case, the bank took unfair advantage of their lack of knowledge, their special weakness or disadvantage. And so the contract for the mortgage was unenforceable. Now, I should point out, this is all we're going to test in our subject, but this has been extended in consumer law so that there are a whole lot of factors that courts would now look listed in that legislation. But because we're not doing consumer legislation, I just want us to concentrate on the common law test, which is still in place. It's still Section 21. So look for a special weakness and disadvantage that the other party knows or should know about and takes advantage of. If you see that, you know that there's unconscionability. And so that brings us to the end of contract formation. Big topic. You've got to work out whether you actually have a contract. A simple apparent contract is the first step. Do you have agreement, offer and acceptance, intent, and consideration? Once you've got what looks like a contract, you've got to make sure it's valid. Was there anything wrong about the contract? Did one of the parties not understand what they were doing? They lacked capacity. Was there an illegal object an unlawful purpose behind it? Did it lack the formality in the few cases that you need formalities? Once you've done that, you need to just make sure that no one really took advantage of anyone else. Were there any vitiating factors? Was there true consent, genuine consent during the contracting? And in particular, we've just looked at 2 ways that you might lack genuine consent: when you use undue influence to get someone to enter a contract, or when you act unconscionably to enter a contract. Both of those mean that the weaker or more manipulated party can go to court and make the contract unenforceable, which is an important point because it means it's at the weaker option. Like if they want to continue on with that contract, they can. So the stronger party can't benefit from their own malfeasance. Like if I act unconscionably to you, I can't say then, well, I diddled you, so I want out of the contract. No. You have to stay in the contract if you did the wrong thing. But the other party has the option of getting out. So it gives them the options. That's why we consider it unenforceable, not that there wasn't a contract. Okay, that's an important consideration and why the language is important. And I think I'll leave you with this slide, which is saying, look, there's many things that are changing. Particularly, I think online agreements and AI have huge implications for how we undertake contract law. Most of that is going to be handled by statute, as I've noted in a couple of places already in the slides, issues such as acceptance. I think it's really important, though, to remember that the common law is always there in our system. These rules are always there, and that the new statutes override it only to the degree of an inconsistency. So they remain here, unless they're overturned by a higher court in the doctrine of precedent, but they'll remain here and then they'll be overlaid with any changes that come about. So at this point, we should be able to say if we followed through and get the answers that we're looking for, we have a contract. In the next module, we look at what's actually in the contract. What did you agree to do? Which are the terms? And then what happens if you don't follow through or don't do what you promised to do in the contract.